a chance and
Sorry.
oh, that's okay. That's okay.
Okay, we can start again. Let's go.
Okay, so now we're on.
Okay.
So I'll just jump into it. We've got about 40 minutes, and then we're going to take time for questions at the end.
Okay.
So I may have to sort of rush through a few things, but that's okay. Now, estate planning for geniuses was a title I picked, not because I think I'm a genius or I expect to make you geniuses, but I can help you think like a genius thinks, I think. So let's try to do that. Oh, Desmond, help. It's not advancing now.
Should I go call?
Please. Oh, this has been a fun one. Desmond, yeah, do the balls.
Yeah.
Yeah. Look at that king.
Oh, are you trying to match your slide?
Yes.
Okay, hold on. Okay, try now. There you go.
Thank you. So when it comes to estate planning, there's a lot of decision trees we can go down. One of the things we can decide to do is nothing. So one of the things we need to know is, yeah, what if I do nothing? Well, in Hawaii anyway, you do nothing, no problem. The state of Hawaii is written in the estate plan for you. Now, is it going to do what you want? Maybe, in a lot of circumstances, it might. But the chances are pretty good that the people you want to have making decisions, if you become incapacitated or being in control of your stuff, might not be the ones you would pick based on the way the statute is laid out. So doing nothing for most people is probably not a great option. So is that what's best for you and your ohana? Well, that's something for you to decide. So what should you do? Well, here's where the thinking like a genius comes in. According to Albert Einstein, an intellectual solves problems. A genius avoids them. So that the intellectuals in your family don't have to solve the problem. So the point of this talk is to kind of help you be thinking in terms of looking down the road, foreseeing the kinds of issues that your family might face or that you might face, and figuring out how to avoid those issues rather than having to solve them after the fact.
Sorry. There you go.
Okay. So let's start with a little foundation, the planning pyramid. A lot of times what people think is most important in estate planning is avoiding taxes, avoiding probate. And in Hawaii, those are really important things to do. But are they the most important things to do? Well, what I'd like to suggest, Desmond, is that the screen
Yeah.
be on there permanently?
No, I was just gonna turn it off. I just needed it just to help troubleshoot. Yeah, you're good.
Okay, it's done now. Okay. So what I suggest is the most important part of your estate plan is considering control. Being in control of your stuff now, saying who's going to take control if something happens down the line, you become incapacitated, you pass, who's going to step in, make decisions for you, make decisions regarding your stuff. Next step up.
Oh yeah. There you go.
Is providing for me. Oh, and my spouse. Now, I have my spouse here in parentheses, not because she's an afterthought. She's not. She's very important. But it's for the same reason that when you take a plane trip, they tell you at the very beginning, they go through the safety briefing. And one of the things they tell you about is the masks. And they tell you that when the mask, if a mask should appear, what do? You grab it and you put it on the person next to you, right? Is that what they tell you? No, they tell you to put it on yourself. Is that because you're selfish? Oh, it's because if you don't put it on yourself first, you're not going to be in a position to help the people sitting around you. So estate planning is kind of like that. You really do have to think about yourself, and that's not being selfish. It's a matter of putting yourself in a position to be able to help the people who, figuratively speaking, are sitting around you on that plane trip. Next step up is taking care of your other family members, including the furry, feathered, scaled, or whatever kind of family members you have. And then the tip of the pyramid, minimizing those taxes and expenses. So we want to do that, but we don't want to do that at the expense of any of these other things. So with that, let me propose this definition of estate plan. First of all, I want to control my stuff while I'm alive and well. Never had anybody object to that. People pretty much agree. Next, I want to plan for me and my loved ones if I become disabled. Now, if you're out there in Zoom land, you might not be able to see, but this if, very small word, it's in red to emphasize it. But it's a very important word because what does anybody here think the chances are of any particular person in this room becoming completely incapacitated and needing help at some point in time before you die? What are your odds? What are our odds? What do you think? No guesses?
Hi.
High. Yeah, try
70%.
70%. It's actually 69 point something, but close enough. 70%. So 7 of us out of 10 in this room, 7 of us out of 10 of people who can hear my voice are going to be incapacitated for some period of time before we die. So we better have something in place to take care of that with respect to our estate plans. And then ultimately, I want to give what I have to whom I want, when I want, the way I want. And when I die, and I pause here, not to rub it in, but all of us are going to die. It's not a matter of if, it's a matter of when I die. I want to make sure my stuff goes to the people I love without unnecessary cost or delay or loss of privacy. So let's jump in and kind of look at some ways of passing our stuff on. One of them is this thing called joint tenancy. And joint tenancy, of course, is where multiple people own interests in the same property. And if one of them dies, title pretty much automatically goes to the survivors until the last one standing gets it. So that's joint tenancy. And joint tenancy is simple in concept, cheap, easy, you can put it in place very readily. But is that a really good idea? Well, let's look at the sad tale of Pennywise and Buck Food. Penny and Buck are a married couple. They have 3 sons. Their sons are named Mo, Larry, and what was the third one? Oh, Curly. So Penny and Buck decide one day, the quickest, easiest estate plan we can put together is just to put the boys on title to all of our stuff. Put them on title to the house. Put them on title to all of our bank accounts. That'll work great, won't it? Well, for 10 years after Penny and Buck do this, yes, everything works great. But then they run into the first rule of creditor-debtor law. And that is what you can touch, your creditor can touch. Corollary to that is what your beneficiary can touch, your beneficiary's creditor can touch. And we're going to see how that plays out a little bit more. But Penny and Buck have done this. They put Mo, Larry, and Curly on title to all of their stuff. And everything does go fine for 10 years. But then that one fateful day, Mo comes running in the house. Mom, Dad, remember that car accident I was in about 3 years ago? Well, these people sued me, and it turns out the judge agreed with them, and it turns out it's my fault. Now they're wanting to collect money from me. And their lawyer is asking me what I own. And I seem to recall, was it 10 years ago, maybe you guys put me on title to your house and on title to your bank accounts. Do you think that's going to be a problem? Well, not to be outdone, Larry comes running in the house. Mom, Dad, bad news. My wife has left me. She wants a divorce. Her lawyer is telling her that she's entitled to half of everything I own. Now, I think I recall maybe 10 years ago, you guys put me on title to the house. You put me on all your bank accounts. Is that going to be a problem? Well, what do you think, guys? Is that going to be a problem? I see nodding heads. Yeah, it potentially is a problem because now there's at least 2 people out there very interested, very motivated to force a sale of the house, to get into the bank accounts in order to satisfy their claims. So what started out seeming like a really good, cheap idea ended up being not so good for Penny and Buck because of the creditors. That was Mo's problem. Creditors, that was Larry's problem. And then don't forget, there's another son, there's Curly. And Curly falls into this very special category that we call them the baboos beneficiaries. This is the technical legal term, at least that's what we use in our office. And of course, baboos generally means stupid. Curly's a great guy. He's very popular. He's the life of every party, but he's not that bright. He's got bad habits. He's got bad friends, and leaving Curly money is basically leaving it to the wind. He's not going to be able to hold on to it at all. So joint tenancy starts out seeming like a really good idea and ending up, at least in this case, not being such a good idea after all. Now, an alternative to joint tenancy would be beneficiary designation. This is where you use TOD or POD, that's transfer on death or pay on death designations on your accounts. You designate beneficiaries on life insurance. You can do it with your retirement plans, annuities. There are various assets that you can designate the beneficiaries of. But the problem is, it's all the same issues that you run into with joint tenancy. There's the creditor issues, because once the recipient gets the asset, it's open to their creditors. It's open to the ex-spouses or whomever else would want to predate upon that person. And then there's the folks that just can't hold on to the money in the first place. So beneficiary designation, I mean, we have to do it on some level in all of our estate plans, but we have to do it very carefully because it's got some definite potential downsides. Now, if instead of going either of those routes, well, we can just hold our stuff in our individual names. And in Penny and Buck's case, they could be joint owners with respect to their stuff. But when the survivor dies, there's going to be this thing called probate. And in some states, probate is a snap. It's really not a very big deal at all. In Hawaii, it can be a snap, but it doesn't take very much to make it not a snap. It can be a real mess. And so probate is something that generally we like to help our clients avoid. Another thing that's sort of a corollary to probate is, well, probate is after you die. Well, what if you become incapacitated and nobody has authority to spend your own money on you, on your own care? Well, then your assets have to go through this procedure called a conservatorship. And conservatorship is pretty much probate on steroids. It's got all of the problems with probate and then some. The conservatorship is going to last for your lifetime. And then after you're gone, there has to be a probate to get your assets distributed to the next step. So probate, as a general rule, not a great thing. And there are other disadvantages to probate. There's just delay, there's loss of privacy. Probate is a public proceeding. Anybody who wants can go down and take a look at the file and find out who knows what about you and your family and do who knows what with that information. Probate can also be pretty expensive if it gets complicated. And remember that probate begins with an invitation to come on down and have a fight down at the courthouse on Thursday morning here in the First Circuit anyway. Because everybody who's named in the will, plus everybody who would receive your stuff if you died without a will, is entitled to notice of that proceeding. So if anybody who wants, who's on one of those lists, can come in, challenge who the personal representative is, challenge the terms of the will. So those are other disadvantages of probate. So what do we do instead? Well, one of the kinds of things we can do is this thing called a trust. This is sort of what the law has devised to avoid those problems. And the genius of a trust is it divides the ownership of assets between the trustee, the title holder of the assets, and the beneficiaries, the ones who actually get the benefit from the assets. Now, the elements of a trust are these. First of all, you have the trust maker, and that's not a legal term. That's just the term I like to use. That's the person who makes the trust. The trust maker makes an agreement with a trustee to manage stuff for the benefit of one or more beneficiaries. Now, in Hawaii, and I believe in all 50 states, same person can be trustee and trust maker and beneficiary all at the same time. We can wear all three hats. In order for the trust to work in the first place, something has to change hands from the trust maker to the trustee. That's the stuff. That's the technical legal term we use for the assets. The rule book is that portion of your estate plan that is actually a written document that says this is how the assets are going to be used. This is who's going to be in charge. This is how distributions are going to be made. This is how taxes are going to be paid, and all of those kind of things. So those are the elements of the trust: trust maker, trustee, beneficiary, the trust assets, the stuff, and then the rule book. Well, let's kind of drill down a little bit on trusts. There are many, many different kinds of trusts. Among them are what we call testamentary trust. Does anybody here know what a testamentary trust is? I know you all do, but
Trust of the will.
exactly. So a testamentary trust is one that is spelled out by the terms of your last will and testament. Testamentary trust. Testamentary trusts are great for providing management for your stuff after you're gone. But what do they do for you and your family while you're still alive? Nothing, because they don't exist until you die. So testamentary trusts are pretty rarely used anymore in estate planning, at least in Hawaii. We favor what we call living trusts, trusts that you create while you're alive. Now, a living trust can be revocable or irrevocable. And I happen to have examples of each of those kind of trusts right here. First of all, we'll take a look at the revocable trust. Revocable trust, I like to analogize to the little red wagon. And the little red wagon is sort of a helpful mental image, because if you didn't have one of these when you were a kid, you know somebody who did. So you know how they work. You can take stuff, put it in. If you want to take it out, you take it out. Revocable living trust works exactly the same way. This dollar bill can represent the deed to your house, all of your bank accounts, whatever it is that you own. You can put it into the little red wagon. And then if you want to take it back out again, you've not lost any control over that asset. You could readily take it back out. The reason for doing this in the first place is if you're walking through life with all your stuff just in your arms, not in your little red wagon, something bad happens to you. You become incapacitated. You die. Well, what happens to your stuff? It ends up in a mess on the ground. Who cleans it up? Well, if the reason for the mess is you became incapacitated, then the person who cleans it up is your conservator. That's the person who gets appointed by the court to manage your stuff for you while you're alive. If the reason for the mess is you died, then the person who gets appointed by the court is called your personal representative. At least that's what we call it in Hawaii. In some states, they call it executor. But it's the same thing. It's the person who's responsible for gathering up a dead person's assets, paying the bills, paying the taxes, and making sure that what's left goes where it's supposed to go. Well, if instead of carrying your stuff in your hands, if you had it in your little red wagon, something bad happens to you, the only thing that hits the ground is the handle of the little red wagon. And hopefully attached to your little red wagon is a rule book that's going to say how these assets are administered. In the rule book, there's going to be the investment instructions. That's what goes into the little red wagon. The distribution instructions, that's what comes out. The successor trustee instructions, that's who picks up the handle and pulls it from here on out. So that's the revocable trust. Now, in contrast to the revocable trust is the irrevocable trust. So with the irrevocable trust, what happens is you take the assets, you put them in, then you put a lid on. Can you get the assets back out? Well, it depends on what the rule book says. But the general idea is once they're in here until the trustee makes the determination to make a distribution. Why would you want to do an irrevocable trust? Well, there could be a lot of reasons for irrevocable trusts. Among them, we talked about the problem of passing assets on to your kids and exposing those assets to your kids' creditors, the predators, your kids' lack of maturity. Well, what you can do by passing your assets on rather than saying, well, here, when I die, trust terminates and all the assets go out to the kids, you can say, well, whatever's in the revocable trust goes out to the kids, each in their own little hollow box, their own little irrevocable trust that's going to be guided by the rule book that's going to say things like, well, the child can get distributions for, and you fill in the blank. And the benefit of having this kind of trust, as long as it's structured correctly, is that the creditors, the predators, the child's immaturity is not going to rob this trust of its assets. Now, in order for the trust to work, your child can be a trustee of this trust, but they can't have control over making distributions to themselves. They can have control over the investments. They can pay bills other than paying themselves. But to get a distribution out of the trust, this trust is going to have, if you want to have it protected, it's going to have what we call a distribution trustee. Distribution trustee is a neutral third party, someone who is not the beneficiary spouse, parent, descendant, sibling, employee, but it can be anybody else in the world. It can be the beneficiary's best friend. It can be beneficiary's uncle, cousin. It could be a bank or a trust company if that's what the beneficiary wants. And you can give the beneficiary the ability to remove and replace that distribution trustee at will. So if you want to give your kids maximum control over this trust while giving their creditors and predators no control over this trust, you can say, yeah, you get to pick your distribution trustee and you can change them at will. Now, not all parents want to do that. Some parents want to say, yeah, I like the idea of that irrevocable trust, but I don't want my kid making the decisions as to when and where they're going to get the money out of it. I want that left to the trustee's discretion. So those are all options that we can build into our rule books. Now, let's go through a couple of issues. Oh, Desmond? Oh,
There you go.
that you can address in your rule book with respect to your revocable trust. The first one is kind of subtle. This doesn't come up in every case, thank God, but it comes up often enough that it's helpful to have a mechanism built into your trust for your own incapacity in terms of what if you're perfectly capable of running your trust for a certain amount of time, but then suddenly you're not able anymore. You're the only person on the planet who doesn't know it. I saw this play out in a situation where a senior family member developed Parkinson's, and the Parkinson's flowered into full-fledged dementia. And right before he died, senior family member took a large estate and made it a small estate with some very bad decisions. There was no mechanism built into the estate plan to have the kids be able to say, for example, hey, Grandpa, you really shouldn't be in control of it. We should move on. You're still the beneficiary, but you shouldn't be in control of this trusting. And so what you can do is you can build into the trust what we call the disability panel. These are people that you handpick ahead of time to be able to fire you as trustee of your very own trust. And that sounds kind of extreme, but if you've been in the situation where this is necessary, you've seen that it's a really good idea to have that disability panel in place. So who can be on the disability panel? Whoever you trust to make that call if it's in your best interest and if it's in your family's best interest. So it could be spouse, could be your treating physician, it could be your kids, or some combination of those. It could be, just another trusted friend or relative, but not a bad idea to build in that mechanism to be able to avoid the problems of you becoming incapacitated and your assets being in limbo or your assets being wasted. Next, we've got the specter of the next spouse. And I'll illustrate this one with a story. I hope I can stay in the camera if I sit down. Am I still there? Can you tell? Well, you can. Yes. Okay. So Fred and Wilma are sitting on their back porch one evening. And it's a beautiful time of night. The sun has just gone down. The breeze has just started to pick up. The birds have all found their nests in the trees. And Fred turns to Wilma, his wife, and says, Wilma, if I died, would you remarry? Wilma says, what's going on, Fred? Are you okay? No, Fred, Wilma, I'm fine. I just want you to know, I've been thinking about this. I just want you to know, if I die, it's okay with me if you remarry. Wilma says, okay. A couple of minutes later, Fred turns to her again and he says, Wilma, if I died and you remarried, would you have your new husband come and live in our house? And Wilma says, Fred, I'm not real comfortable having this conversation right now. Can we talk about something else? Fred says, Wilma, I'm sorry, it's just, this has been on my mind. I need to tell you. If I die, you remarry, it's okay with me if your new husband comes and lives in our house. Wilma says, okay. A couple minutes later, Fred turns to Wilma again and he says, you know, Wilma, if I die, Wilma says at this point, look, Fred, you have officially spoiled the evening. I'm going in. You just enjoy it out here yourself. Fred says, no, no, wait, Wilma, wait, please. I need you to know, if I die and you remarry, it's okay with me if you let your new husband drive my pickup truck. And I have one more question, I promise. Last question. If I die and you remarry, will you let your new husband use my golf clubs? Wilma says, absolutely not. Fred says, really? Why? Wilma says, he's left-handed. Now, a lot of our clients, when we have the conversation about remarriage with them, will say some variation on, oh, do I care? I'm going to be gone, whatever. But I would say more than 50% say, yeah, I care. I don't want my spouse remarrying and then seeing my stuff go to the next spouse's kids or the next spouse and to the exclusion of my kids. So what we can do is we can build into our rule books provisions that actually say things like, honey, you want to get remarried? Knock yourself out, but you can't be a beneficiary of my trust anymore. Or there can be special limitations put on the spouse's ability to get into the trust. Maybe they can't be the trustee anymore. Maybe they can't have the ability to hire and fire trustees. So it's up to the individual situation. I mean, you have to look down the line for yourself and decide what's going to avoid problems for me and my family. Next point is creditor protection. We talked about that with, remember, poor Mo getting a car accident. Well, we can build protection for our kids by having the right provisions in our rule books so that our kids are going to be able to benefit from their inheritance. Their creditors won't. Similarly, their ex-spouses won't. Most of our clients, when we talk about this, say, yeah, I want my stuff to go to my kids, but not their ex-spouses. Some clients are real picky about that, honestly. Some clients say, no, that ex-spouse would probably deserve to get something out of this. We get the nice thing is we have the freedom to build our rule books the way we want to build them. We get to make the rules. Special needs individuals. Sometimes there is a beneficiary who maybe is receiving governmental benefits, and if we leave them assets, they're going to lose those benefits because now all of a sudden they're rich, meaning they got more than $2,000. So what we can do is we can build what we call supplemental needs trusts to provide for the special needs individuals, can provide all of the extras that the government won't provide. The government's not going to take them on trips. The government's not going to buy them a new wheelchair or bed or computer every time they want one. But we can build these supplemental needs trusts to basically enhance the quality of life for our special needs beneficiaries. And a lot of times we see this where our clients are supporting, say, a senior family member. They're supporting a mom or a dad who's incapacitated. And mom or dad is receiving benefits, and they don't want to sacrifice those benefits by giving them too much assets, can actually create a supplemental needs trust for the senior family member. And then finally, one of the kinds of things we can do is we can promote our values in our estate plans. What that means is maybe you don't want your kids to spend all of their inheritance on booze. Maybe you want to encourage them to finish college. So we can build rules into our estate plans that say things like, trustee, in order to make or before you make a distribution to this beneficiary, they got to pass a test. Whether it's for drugs or alcohol or whatever it is. You can build in rules that say, please pay for the education of my child. And when they graduate, when they get that bachelor's degree, give them a bonus, give them X dollars. We had a client who came up with a really complicated schedule that basically provided for a bonus when the child got their bachelor's degree, when they got their master's degree, when they got their doctorate degree. They wanted to encourage that education. And we've even had clients who got a lot more granular than that. They've built things in to provide bonuses for the kid while they're in school. I want you to give child $500 a month just for spending money. But at the end of the semester, if they can show you straight A's, double it. Or whatever rule you want to make to be able to encourage your kids to actually go to class and get good grades. So we can build our values into our estate plans as well by putting those rules into our rule books that accomplish those purposes. Now, one of the most important choices that's going to be made in the estate planning process is picking who's going to be the trustee. Trustee can be an individual. It can be a bank or a trust company. It can be a group of people or an individual and a bank or a trust company. So we can, by looking down the road and just understanding our family and understanding their needs, sort of predict, well, what would be the best for my family in terms of who's going to be running the show after I'm gone. We talked about that independent distribution trustee. Remember when we were talking about the irrevocable trust that you leave your kid when instead of giving them the money, you give them the nice wrapped up gift? Well, the independent distribution trustee, again, is someone who's not the beneficiary, the spouse, parent, descendant, sibling, or employee. And it's up to you whether you give the ability to the child to hire and fire the trustee at will. You can say, too bad, it's going to be XYZ Bank, or you can say, hey, you pick it. So you can either prescribe in your rule book exactly who the trustee is, or you can just leave it open and say, well, you got to pick a trustee. It's got to be this neutral third party because I want to build in that protection, but I want to give you maximum control. And by the way, when you're giving your beneficiaries that control, you can also say, look, when you die, you get to say where the remaining assets go, if that's what you want to do in your estate plan, if that's what's going to work best in your situation. Alternatively, you can say, well, when you die, it goes to your kids, or it goes to X charity, or it goes wherever you wish. And then finally, there's this concept of what we call a trust protector. And this isn't a super trustee exactly, but it's someone who can sort of look over the trustee's shoulder. And if you've got, let's say, two trustees, two kids, and they decide opposite ways on are we going to sell the house? One says yes, one says no. Well, your trust protector can, in effect, be the tiebreaker, or they can be sort of a mediator to work things through and help the kids come to a decision. If a trustee steps in and they're doing a lousy job, you can give the trustee the power to remove that trustee and replace them. So it's another sort of safety net you can build into the estate plan so you can make sure that your wishes are going to be carried out. Now, remember we talked about our 70% chance of incapacity and needing somebody else to step in. So what do we do in terms of that when it comes to things that are maybe outside of our trust? Well, one of them is something we call an advanced healthcare directive. And that's where you give someone the authority to make all of the healthcare decisions you could make for yourself, but you give that to somebody else to be able to make them if, say, you're in a coma or you're just not able to communicate. And the advanced healthcare directive doesn't have to just be that. It can be, well, where am I going to live? You can give your agent under the advanced healthcare directive the power to decide that. Who's going to be my doctor? And ultimately, you can say, well, you're going to be the one who decides when to pull the plug, if it comes to that. Now, what some people like to build in is just, well, when my doctor says it's time to pull the plug, pull the plug. Not everybody's comfortable with that. A lot of times people want to make that a family decision rather than simply a medical decision. And a lot of times the decision is great. I mean, it's really hard to know, is this person going to come out of this coma or not? And if you listen to, one faction and they're saying, no, it's time to pull the plug, versus the other faction who says, yeah, but you don't know at best. She's survived worse than this. She's gonna come out of this thing. And in my personal experience, I've had to actually litigate some of these kind of cases. The doctors are right 50% of the time. And that's just my anecdotal experience. But that means 50% of the time, Aunt Bess did come out of that coma, and she was real glad that somebody stepped up to the plate and made sure that the plug wasn't pulled when the doctors were saying, let's pull the plug. And that, by the way, is what we refer to as the God power. Say when to pull that plug. So you get to decide. You get to decide in your own estate plan. You could build the rule into your estate plan that says when that plug is going to be pulled under what circumstance. HIPAA is a privacy statute. Actually, there's federal and state versions of it, but they basically make our health information absolutely sacred. Not your kids, your spouse, your mom, not nobody can get that information out of your medical providers without your written permission. So that's kind of a good thing. Privacy is wonderful. We had a situation that we dealt with where this lady who was the life of the Zumba group, she was the oldest one in the Zumba group, and she was also the most energetic one. And then one day she stopped coming to Zumba, and all of her friends are saying, oh, what's going on? What's going on? Where's our friend? And what they eventually found out is she'd had a stroke. She was in a nursing home, and her sister, who lived in another state, was not allowing that information to be disseminated. So her friends couldn't come visit her. But as she was recovering, she felt like she was buried alive because the people that she wanted to have come see her and encourage her weren't able because nobody would tell them what was going on. And so for this particular client, one of the other students in the Zumba class, she wanted to build special provisions into her HIPAA authorization that gave her friends the ability to find out what was going on so that they could provide the support and the encouragement that they've been providing all along. A durable power of attorney is sort of a plan B. It's a backup. If your stuff is in your trust will take care of it. And your trustee can manage the stuff, make distributions as appropriate. But if you own something that's not actually in your trust, that can be a real problem. So you give a trusted individual your power of attorney to be able to deal with that. And it may be, well, just transfer it into my trust and let the trustee take care of it. And those people might be the same people anyway. But it might be, just doing other things with assets to be able to spend them on your income capacity. Paying for nursing home care. This is a big one, and it's something that all of us need to address. If you do not have long-term care insurance, look into some way to get it, or look into some way to provide for your long-term care. Now, maybe you've got a couple of $1 million cash sitting in the bank, in which case you're probably fine in terms of long-term care. But if you don't, you might want to have some third-party help. And in an extreme case, you might want to have your beneficiary be able to apply for Medicaid or a governmental benefit that's going to help pay those expenses. Estate tax. Here's a really fun thing. And it's been really nice in terms of the US estate tax, where now we have a $15 million exclusion per person, meaning that a married couple can give away $30 million completely federal estate tax free. So that means most of my clients and most of us don't have to worry about federal estate tax. And that $15 million number applies in 2026, but presumably it's going to go up in succeeding years because it will be adjusted for inflation. Whatever goes over that line, however, is going to be subject to federal estate tax at the rate of 40%, just a flat 40%. It's payable within 9 months of date of death, and it's payable in cash. The IRS does not accept chickens. They don't accept real estate. So if you're real estate rich and cash poor, that can be a real issue. So liquidity planning sometimes comes into the estate planning process as well. One nice thing about the federal law is if I've got $1 million estate and my wife has a $20 million estate and I go first, simply by filing an estate tax return, my wife can take the unused portion of my 15 million and port it over to her estate so that when she dies, she's going to get her 15 million or whatever that number is at the time, plus my unused 14 million to be able to shelter assets from estate tax. Pretty cool. Now, Hawaii, not to be left out of the taxing process, of course, has its own estate tax. And it's a little different from the federal estate tax. It used to be pretty much mirror image, but it's a little bit different now. First of all, instead of a $15 million exclusion, we've got a $5.49 million exclusion. Significantly less than the federal exclusion, but still fairly generous. Now, the Hawaii exclusion, unlike the federal exclusion, is not adjusted for inflation. So that's not going to go up over time. It's $5.49 million until the folks over there in the big square building change the rules again. The Hawaii rules allow portability, so that's kind of nice. So between husband and wife, they can give away almost $11 million worth of stuff, Hawaii estate tax. And the Hawaii estate tax rates are a little bit different in that they're graduated, kind of like the income tax rates are. They start out at about 10 and it goes up to about 20 at the max. But you can see how between the federal and the state estate tax, if you've got a big enough estate, a significant amount is going to go other than where you would want it to go. So your options for where your stuff goes after you're gone are to the people you want to enjoy it in the way you want them to enjoy it. This is the idea, right? The next option is to the ones you don't want to enjoy it, your kids' ex-spouses, their creditors, whomever, or to your kids in ways that you don't want them to enjoy it by, buying drugs and alcohol or, whatever, spending it in ways that you would not want them to spend it. Another option in the menu is the charities that you love. And charities are wonderful recipients after you're gone for a lot of reasons. There are tax reasons, but also non-tax reasons. And then the final option is to the government, taxes. So these are kind of our choices. And if you're aware of the choices, you can think ahead and say, well, I like this one and not this one and this one. And you can arrange your estate plan so that your wishes are going to be carried out. So it's just about time for question and answer period. So let me just finish this up. What if I do nothing? The question I asked at the very beginning. Well, there's going to be problems to solve. You're going to keep those intellectuals in the family busy solving those problems. Is that what's best? Well, not for me, not for most people. So what do? Well, what I would encourage is think like a genius. Think in a way that's going to avoid problems later on. Remember, according to Albert Einstein, an intellectual solves problems, whereas a genius avoids them. And so now I don't think I've raised anybody's IQ, but congratulations. You are now a genius. And a lot of the stuff that I talked about is in this book, Estate Planning for Geniuses. And by the way, this picture is not Einstein. I wanted to use that sort of iconic picture of Einstein, with him sticking out his tongue. And at the time, this is 2023, it was still under copyright. So I couldn't use Einstein. So I found some dumb guy to impersonate Einstein. My publisher, fortunately, if you use this QR code, you can get a discounted version of the book. But it's time for question and answer.
We'll open up to the floor for questions here in the room. And then for those on Zoom, just go ahead and put your questions in the chat box, and then I'll read it out loud for Scott to answer. Do we want to start with any questions in the conference room?
Yes.
Nobody else have. So with the distribution trustee, with the asset protection that you had mentioned, what if there's a situation where beneficiary, the parent wanted the beneficiary or child to, at a certain age, achieve full trusteeship, and or the option to become sole trustee, and would the trust, if the beneficiary declined that sole trusteeship, and had the option to do that and continue with the asset protection, would asset protection survive that option, or would that be seen as they should have to take that mandatorily to keep that asset protection?
Well, I wouldn't have that be a toggle that the beneficiary can decide.
Okay,
And we've got some commercial litigators, some litigators in the room, and then maybe you've collected money from estates, but I would say that if you give the beneficiary the option, the creditor is probably gonna be able to reach in there,
even if they decline it,
because you gave them the
because they
option.
had the option, that was
They
their.
could have gotten that money to pay their debts, they declined it.
Okay.
I would
I would
probably
say
think
that
that it's
at
better
that
to
point.
avoid that, and maybe I'm being over conservative on that, but that would be, do any of the litigators agree or disagree?
I'm not a litigator, but I'm gonna respond to your question. Good question. Go read the Uniform Trust Code for Hawaii. There's a section on spendthrift trusts. I think it's section 5 or 6. And they may answer your question, because it tells us when somebody, a creditor, can access so-called creditor claim protection trusts or spendthrift trusts.
Okay, in case you couldn't hear that on Zoom, Colin just said that within the Uniform Trust Code, there are provisions for when a creditor can invade a quote unquote spendthrift trust.
Specifically Hawaii Uniform Trust Code, not the national one.
Okay, specifically the Hawaii, because we don't necessarily make our
We change
uniform rules uniform.
We
We
changed it.
make our own, yeah.
We got some questions on Zoom. Does the Hawaii estate tax have portability as well?
Yes.
Up to 10.98 million
Yes,
for the surviving spouse.
yes. Hawaii does allow for portability. So basically, on the Hawaii side, just like it's on the federal side, you gotta prepare that estate tax return, you gotta file it, but there's not gonna be any tax to pay. It's just to sort of reserve the unused portion of the person's exclusion.
Next question on Zoom. Do you recommend bank trustee if there are only 2 real estate properties in the trust? All other assets are TOD. I don't know what TOD
Oh,
is.
probably transfer on death.
Transfer on debt.
Well, it depends on the situation. Corporate trustees are great for providing for management and for enforcing rules like you gotta pass a drug test before there's a distribution. I mean, who would you rather have making that decision? Do you want Uncle Willie, kind old Uncle Willie, to say, well, maybe this time we'll make the distribution? Or do you want the bank that's gonna say, no, it says right here, pass the drug test or pound sand, you don't get a distribution. So corporate trustees are great for a lot of purposes. I'm not sure if that was the point of the question.
Well, yeah, that was what was sent in on Zoom. But any other questions in the room or on Zoom? If not, do you have like any contact information if that you're willing to give out, Scott?
Well, at the very beginning,
Here,
there is
I-
my website. If you want to just,
I can exit out, go back to the top.
yeah. So if anybody wanted to contact me, they could, by way of there's our office phone number and our website. And my email address is the first 4 letters of my last name, maku@est8planning.com, if anybody wanted to contact me by email.
All right. Well, if there's no other questions,
Scott, don't you have a website too?
Yeah, that's it, www.estate planning.com.
All right. I just wanted to make sure everybody knew.
Thank you, dear friend.
God knows I'm an idiot. I missed it.
He did that on purpose. Colin is a good.
oh, I think we got another question on Zoom. Are there lots of disputes or litigation among heirs? And what is it about?
Oh, goodness. Yes, there are, and there are about all kinds of
I feel like
things.
we open up a can of worms here.
Yes.
Yeah,
that's another workshop.
No, more like one of those things that come in the boat, bring
The
merchandise.
Matson container,
yeah.
that's, it's bigger than a can of worms. And we have some people in the room who deal with those kind of things on Thursday mornings down at the First Circuit. So we know, yeah, the disputes come in all flavors. Who should be the trustee? Who should, be the one in charge? Was the person who signed the documents competent when they signed them? Is this really a fair distribution of the assets? But mom always promised me I would get the grandfather clock, and now, whatever it is. We've seen a lot of situations where there are fights over anything you can imagine. So the more you can nail things down in your rule book, the better off your family's gonna be.
Okay, all right, well, if that's all the questions we have for today, I want to thank Scott Kulkani for presenting it for today, for this month's coffee hour on behalf of the Senior Counsel Division. Thank you, everyone, and we do apologize if anyone ran into any audio issues. We will distribute a recording of this presentation at around a later date, maybe sometime next week. So if you go to hsba.org and then go to the Senior Counsel Division page, you'll be able to access the recording. All right, thank you, Scott, and thank you everyone for attending.
So the recording will have the slides also.
Yes, so it'll show the slides on there.